Well, good afternoon. Welcome to the Senior Concerns Seminar Series. So happy to have you all with us today for this very important topic. I'm Martha Shapiro. I'm the Director of Programs at Senior Concerns. If you're not familiar with Senior Concerns, I just want to briefly let you know about some of our programs and services. We operate a caregiver resource center where if you are caring for an aging family member or friend, you are welcome to call and speak with a social worker to go over your situation and learn about resources and supports. We also have several different caregiver support groups that are right now operating over Zoom for you. We have senior advocates as well who can answer questions on resources, benefits, information, insurances, you name it. They are here for you. So you can just call our Senior Concerns phone number anytime. We also operate the Meals on Wheels program for Thousand Oaks and Newbury Park. And since the pandemic, we've started a volunteer grocery shopping program, an emergency food pantry for seniors, and also a new in-home comprehensive geriatric assessment program to help support people at home as they age in place. So you can always reach out to us at Senior Concerns to learn more. So we're excited about our seminar today. I want to first just give you a little bit of housekeeping. We are recording this seminar so that we can have it up on our website in case you miss it and you want to hear it again, or you want to share it with a friend of yours who might benefit from the information. We are watching this today in webinar mode. So that means that you as the audience are in listen only mode. So we can't see you, but you can still interact with us and ask your questions. I have enabled closed captioning, so you should all be seeing our words being typed onto the screen. If you need to see them larger, you do have the option. There should be a little CC button that says live transcript. If you move your cursor over it, there's a little arrow, and you can click that arrow, and then it will give you an option to click on subtitle settings. And that's where if you need to make the subtitles larger, you can go into the settings and enlarge the font. You'll also see when you move your cursor at the bottom of your screen, there's a place to type into chat and also a place for Q&A. So the chat would be great if you need to let me know if you're having some sort of technical difficulty. You can chat to me there. And the Q&A is great to put in your questions for our speaker today. She would be happy to answer your questions. She will start by providing her presentation, and then she will view the questions in the Q&A box. But don't worry if you have a question as she's speaking, just type it in as soon as you think of it. We don't want you to forget. It will just sit and wait for her for when she's done with her presentation. So with that being said, I'd love to get going today. I'm really happy that we have Elana Eden from the Housing Rights Center with us today. She's the Director of Media, Outreach, and Education at the Housing Rights Center. The Housing Rights Center is the nation's largest nonprofit civil rights organization dedicated to securing and promoting fair housing. She's going to give you some more information on what they do and some really important information for both renters and landlords. So I thank you so much, Elana, for being with us today.
Thank you so much for having me. I am happy to be here, and thank you for that nice introduction. I'm going to share my screen now and show the slides that I have for today. Does everybody see that? Are they coming through? Great. All right. Well, yeah. So, as Martha mentioned, my name is Elana, and I am with the Housing Rights Center. And today I'm going to talk about basically two topics, and they are fair housing protections, and also protections that are in place because of COVID-19. So these will have to do with rent, evictions, foreclosures, those types of things. And then I do want to share a couple of resources as well. But first, I want to talk just a little bit about who we are at the Housing Rights Center, so you know who's talking to you and also what services you may be able to get from us. We were founded in 1968, along with the passage of the Federal Fair Housing Act, which basically banned discrimination in housing and protected civil rights in housing. And so that is what we exist to enforce and promote. And we serve all of Ventura County, as well as most of Los Angeles County. And we have all of our services available for free, no special requirements or eligibility, and available in multiple languages. The services that we have include, first of all, our Housing Rights Hotline. So this is a number where you can call and speak to one of our trained housing rights counselors about any type of question that you may have about housing, particularly rental housing, but it can be anything from a rent increase to repairs, habitability, an eviction, whatever the case may be. You can ask your questions and we can provide you with some legal information on what your options are, what your rights are, what perhaps your responsibilities are, all of that stuff. So I will share these slides out afterward, but I do still want to just read out the number. It's 1-800-477-5977. And we also have a TTY number for deaf and hard of hearing clients. That is 213-201-0867. You can also email us at info@housingrightscenter.org. And since coronavirus, we've also started offering appointments. So if you want to make an appointment rather than call the hotline, you can do that online at housingrightscenter.org/help. And all of this information is there as well. So all of these conversations are currently going to be over the phone, or if you prefer, we can also do Zoom, but we're not doing in person right now. So if our housing counselors hear about a case that sounds like discrimination, which we will talk about in a little bit, we can actually take that on internally and have a caseworker work on that case and try to find a resolution. And that can be a variety of different things, which we'll go into. But if, for some reason, we can't find some resolution, we can and we do litigate. It is not very common. It's pretty rare that we need to do this, but it is effective in enforcing fair housing law, so we do it when we need to. And that is free as well. Everything is free, so if we were to represent someone in litigation, that would also be free. We do lots of outreach and education, which I'll talk about in just a second, and we produce a listing of affordable housing opportunities in the Ventura and LA areas. So it's called Project Place, and it is a listing of affordable housing that we know of: senior housing, low-income housing, veteran housing, all these different types, as well as information on rental assistance programs that we're aware of, and a basic rundown of some protections and things that you might need to know if you're looking for a place. So that's available currently online on our website and via our email list. I'm happy to send it to anyone who would like it. So our outreach events are also currently remote. So we are doing a lot of them. Every week we basically have a rotation where on Mondays we do a live Q&A. And this is based on real questions that people have submitted to us, anonymized of course, but it reflects, what's really going on for people right now. And so that is a good place to look. We also do housing rights workshops on Tuesdays in English and Thursdays in Spanish. These focus on fair housing. And on Fridays at 2 p.m., we give an update on the latest COVID-19 related protections. We're going to talk about both of those topics today, but if you ever want to catch them again or get the updates, you can always find them on our website, on our social media, or you can email me. All right, so having said a little bit about us, we do actually have kind of a lot of information today, so I wanna get right into it. So first, fair housing. So, fair housing is about uh, treatment in housing that is based on personal characteristics. And under federal law, the Fair Housing Act, there are a certain set of characteristics that are protected under that law. So, federally, nationwide, they are race, color, religion, sex, national origin, familial status, and disability, mental or physical disability. California has additional protected characteristics, or protected classes, as the law calls them. In California, we are also protected based on our marital status, ancestry, sexual orientation, gender identity and expression, age, source of income, medical condition, military or veteran status, and genetic information. So, a broad set of protections there. And age in this case is referring to over 40, whereas familial status, federally, is referring to households with children. So there's age-related protections from both the state and the nation. One of the protections that I mentioned was source of income. And what this means is that it's referring to basically assistance. Anyone who receives any type of rental assistance, subsidy, financial aid, whatever the case may be, it counts as income. So if applying for a place that has an income restriction, or rather an income threshold, right? You have to make, let's say, 3 times the rent, or various amounts that we see. Any assistance absolutely is treated the same as any other form of income. So a housing provider, a landlord, a manager, a rental agent cannot treat that income or the person who receives that income any differently based on that. And so this includes Section 8. I think it is worth noting. That's a common question that we get. So this means that it is illegal to apply different terms or conditions to someone because they'll be paying with Section 8, to post ads saying that someone with Section 8 will not be accepted, to refuse to accept a Section 8 voucher. All of this must be treated just as if this person were paying with money from a job, money from a bank, money from family, whatever the case may be. So that's the first definition of the day. We also have additional laws in California that provide other protections. So we have protections for survivors of domestic violence and other violent crimes that, for example, they could break a lease if they needed to. We have protections based on immigration status or citizenship status. It is illegal for a housing provider to use that information against someone or to retaliate by, threatening someone's status. We have protections for primary language, that a tenant can do, or a prospective tenant can do business in their primary language, so they can read the lease in their primary language. Arbitrary reasons. If it's not covered here, but it's being used as a reason to discriminate, the law in California says that is illegal too. And of course, we also in California have a law against hate crimes, meaning any type of violence, threats, intimidation that is based on someone's protected characteristics is not only illegal because it's violence, threats, or intimidation, but also illegal as a form of discrimination. So fair housing laws, they apply in pretty much every housing situation, every residential situation that you can think of. Whether it is renting, buying, lending, getting a mortgage from a bank, prospectively seeking a home, so you're not living there yet, but you're just looking, right? You're protected in that situation too. And it also applies in pretty much every type of housing that you can think of. So apartments, condos, single family homes, houses, right? Duplexes, and we could add here triplexes, fourplexes, residential hotels and motels, transitional shelters, mobile home parks, even vacant lots, and short-term rentals as well. So they are very expansive. So here are some of the specific practices that are considered violations of fair housing laws. These are considered discrimination if they are based on someone's protected characteristics, right? Refusal to sell or rent housing, just straight out refusal. That's perhaps the most blatant, obvious one. Refusal to negotiate for the sale or rental of housing, if that would otherwise be standard. Saying that housing is unavailable when it is available. That's a big one as well. So saying we have no vacancies, but in fact there are vacancies and maybe the next person would hear something different. Applying different terms or rules. So that could be different terms in the application, like maybe a harsher standard for income or credit or rental history. It could be different rules in the home once you live there. Things about who is allowed to be outside, who is allowed to do certain things. If it is, based on, if the difference appears to be based on someone's protected characteristics, then it's discrimination. Discrimination based on association. So, if in fact the person being targeted is not someone who lives there, but someone who's coming to visit, a caretaker, for instance, or a family member or a friend, they are protected by extension. And tenants are protected as well if any discrimination happens toward that other person. Threats, intimidation, and harassment, we sort of covered. Steering is one that I think people may not know about. Steering has to do with diverting where people can live, diverting people to a different area based on, again, some personal characteristic of theirs. So it could be one common example that we see is within a building, like a family, saying no children on the second floor. This is a common one that we see. So that a whole category of people, families, cannot live in a whole part of the building. That's steering. But it could also be a different building, steering people to another building by the same owner, or a different neighborhood, right? All of these things do happen, and they are illegal. Discriminatory statements or advertising. So it could be a verbal statement, it could be a posted ad, and there are so many examples of these. Again, with families, we often see no children or adults only. I mentioned earlier, no Section 8 would be an example of discriminatory advertising. If an ad said, this is ideal for young professionals, that could be age discrimination. And it is age discrimination, in fact. So things like this. Any sort of advertising that is about who they want to see there is pretty likely to be discriminatory. And lastly, refusal to grant a reasonable accommodation or modification for a tenant with a disability. I'm going to go more into that one a little bit later because there's more to unpack there. But first, I do want to answer this question of what are the factors that a landlord can use to accept or reject or decide about a tenant. And basically, the lens to use is this related to my business? Does this impact my ability to do business as a landlord? So income level, for example, this is something that is allowed to be a criteria for selecting a tenant. Can they pay the rent? Credit scores. This is allowed as well. Have they paid rent on time in the past or other bills? References from past landlords. This can tell the landlord whether they have been a good tenant in the past. It's also okay for a property to have a uniform rule about no smoking or no pets. As long as it is not applied in a discriminatory way, it's applied to everyone equally, that is totally fine. And that, of course, would mean that they would reject a tenant who wanted to smoke on the property or a tenant who wanted to live with a pet, right? Criminal history is also a question that the landlord can ask, or the rental agent or whoever's acting on behalf of the property owner can ask. However, it should not be a uniform policy. So this is different. This should be case by case. And again, the question to keep in mind is, how does this impact my ability to run my business as a landlord? If there's no actual cause for concern that relates to the housing, there may not be a good case for rejecting that tenant based on their criminal history. So if someone shoplifted when they were 21 and now they are 58 and they're trying to rent a home, that's not a great basis for denying the tenancy. But if someone, I often can't even think of a good example of this, but if someone set fire to their landlord's home last year, that might be something you might be more interested in knowing, right? So the business lens here. Now returning to the question of disabilities. And so the basic principle here is that a tenant with a disability has the same right to get as much use out of their housing that they're paying for, they're paying the same amount, right, as a tenant without a disability. And a disability under the law, I do want to flag, is not necessarily what we would consider a disability. So you may not consider yourself to have a disability, and yet you may still be protected under this law. It really is about anything that, any sort of health or medical or physical or mental condition that causes some substantial impairments to your daily life. And that can mean a lot of things. So it's pretty broad. COVID-19, for example, is covered under these protections. And so to fulfill this right that tenants with disabilities have, they can request certain changes or exceptions that are related to their disability that would give them greater use of the housing. If the tenant their disability is not clear, is not readily apparent, is what the law says, then the landlord can request verification. And the standard for when a landlord gets to say no to a request is actually pretty high. I'm going to look at some common examples in just a second, but basically, because this is the tenant's right, it's a pretty high standard to not fulfill it. So typically the standard is an undue burden, right? Not just a burden, but an undue burden. Or that it fundamentally changes the nature of the business in some way. Like, for example, if someone with a disability requested to not pay rent, this would be a fundamental change to the business of providing rental housing, so that would not be required to fulfill. But if that does happen, the landlord and the tenant should have a dialogue. So the landlord has to come back to the tenant and say, we cannot do that, here is why. Can we try this instead? And the tenant gets to say, no, that doesn't work for me. Can we try something else? And you have to go through that process until either you've exhausted every possibility or you found some kind of alternative. So here are some common examples of what that might look like. So accommodations and modifications under the law, they are the principle is the same. The main difference is that accommodations are considered to be changes to services or policies, whereas modifications are considered to be physical changes to the building or the unit or something like this. So some really common accommodation requests that we see and that are typically considered reasonable and should be granted would be, for example, changing the date that rent is due. If someone receives disability or some other form of assistance and it doesn't come in until the 4th, they won't be able to pay their rent on the 1st, right? It is a reasonable request for the tenant to say, I need to pay my rent on the 4th or the 5th to be safe. This is reasonable, and if there is any cost associated with that, if the landlord has to pay staff to make that change in the database or whatever the case is, the landlord bears that cost. So accommodations, changes to services or policies, should not cost the tenant anything. And this includes also some more common examples, having a service animal or a support animal. It doesn't have to rise to the highest threshold. It could be an emotional support animal. Or having a live-in caregiver. In both of these situations, the tenant should not be paying additional rent or additional deposits to have a service animal or a live-in caregiver. And again, this is because that would be essentially charging the tenant for having a disability and requiring some aid. So that would be illegal. So if anyone has a service animal, even if the building has a no pets policy, right, the accommodation is waiving the no pets policy to allow the service animal. That's the exception that's being requested. And the landlord cannot charge pet rent, additional rent, or a pet deposit. So no charges to the tenant for this. And again, the live-in caregiver, the same thing. That person does not pay rent. Other common examples would be changing a parking space because perhaps a mobility impairment, transferring units, maybe something in the apartment or in the house or whatever altogether is causing a problem. Maybe there's smoke nearby. Maybe there's some kind of hazard inside the unit, right? If there are other units available, then transferring units would be a reasonable request. Modifications, again, similar principle, but this is about making changes to the building or to the unit. So for example, a wheelchair ramp, grab bars in the bathroom, lowering countertops to be reached from a seated position, removing carpet. Sometimes carpet is removed to avoid like snagging on equipment. Sometimes it is removed because someone has asthma or a respiratory condition, and they would do much better with flooring that doesn't accumulate dust like that. So various things. But in these cases, when it comes to a physical change, the tenant typically does have to bear those costs. So the tenant may have to pay for the modification to a point. If it's something where the property owner or the landlord, they want it to look a certain way, they want it to fit a certain decor or meet their particular standards, the tenant is not required to do all of that. The tenant has to pay for what they need, and if there's any particular things that the housing provider wants, then they need to pay for that. Does that make sense? So if they want the flooring that you replace the carpet with to be a certain tile in a certain color from a certain company or whatever, that is not the tenant's responsibility, as long as the tenant just pays for the basics. And one common request that we're seeing right now, and that we actually encourage, is for tenants who think they may be vulnerable to COVID-19, whether because of age or underlying condition, to request that the landlord delay any reason that they might have to enter your unit, unless it's an emergency. Emergency is a different situation. If the roof is caving in, someone might need to enter. But in a lot of cases, these things can really be delayed. So if it's a viewing, someone wants to come see the place because it's for sale, or a standard inspection, or routine maintenance or preventative maintenance, things like this can probably be delayed. HRC helps with these requests a lot. And again, I just do want to encourage you to think broadly, because there are a lot of things you can ask for that you might not realize. So feel free to contact us if you need any help with this. I can break here to take a couple of questions about fair housing. but I see that the questions primarily don't have to do with fair housing, so I'm going to move on. And maybe we'll answer some of them. All right, so moving into similar but different topics: rent, evictions, foreclosures, all of these things that are coming up right now because of the pandemic. So first of all, rent increases. So California is in a state of emergency. And during a state of emergency, there are laws against price gouging. So for housing, what this looks like is that a landlord may not increase rent by over 10%. And this is indefinite. It lasts until the governor or the state legislature decides to lift the state of emergency. It'll happen someday. We won't be in an emergency anymore. But that's the gist of it. It also says that a landlord cannot evict a tenant in order to then raise the rent by 10%. So that workaround is foreclosed. And it's actually a misdemeanor to do this. So just something to keep in mind. That's a 10% cap on rent increases all throughout California. There is also a statewide law called the Tenant Protection Act, AB 1482, you'll sometimes hear it called. It does not apply based on city. It's not about what jurisdiction you live in. It applies about by property, by type of property. So these are the types of properties that are covered by this. First of all, multifamily homes that are over 15 years old. Also, single family homes or condos if they are owned by a corporation or an LLC with a corporate member, some various technicalities there about what constitutes a corporation, but not just a person. And duplexes if the owner does not also live in the duplex. So it's really designed to target the bigger landlords. Smaller landlords, certainly people who are sharing your home with a renter, this is not applying to you. But what it does, if it does apply in the property that you own or the property that you rent, depending on who I'm talking to on the call, if it does apply, what you get is another limitation on how big a rent increase can be. And it's a big difference from 10%. It is based on the regional cost of living. I apologize, this has the LA metropolitan area, and I believe that Ventura uses its own calculation. I've seen some Ventura agencies use the LA one and some Ventura ones use a different one. So it might be best to consult with the county about their preference if you're not sure. But for the LA metropolitan area, it is 5.7%. It does change over annually, just like other forms of rent control do. So it will be recalculated in April. But until then, we're working with 5.7%. That's the cap on rent increases that can be given to these types of properties. We know that your property is not covered if you have local rent control, if it's affordable subsidized housing, or if it's a dorm. But even if you're not covered, for a larger rent increase that we might see after the state of emergency ends, 90 days notice will be required. So there's different amounts of notice for different things, but for a rent increase of over 10% after the emergency, 90 days notice will be required. I know this is a confusing portion. Housing law is like that sometimes, unfortunately. All right, so I want to talk now about evictions. So the same law that we were just talking about, the Tenant Protection Act, also has eviction protections. And normally, these eviction protections only apply in, again, those certain types of housing because of COVID-19. These protections have been extended everywhere in California. It does not matter what type of property it is. And what they are is called just cause eviction protections. Just cause, meaning a fair reason. It basically limits or narrows down the number of reasons that someone can be evicted. And the landlord must state a reason, and it must be one of these valid reasons. There's about a dozen of them total, but they are broken up into two categories where the tenant is at fault, they did something, and where the tenant has no fault. So, an at fault reason would include maybe the tenant broke the lease, or certainly any type of criminal activity on the property is always a valid reason. Any type of threat to health or safety is always a valid reason for eviction. Um, Nuisance, certainly criminal nuisance, a valid reason for eviction. No fault reasons, which are not the fault of the tenant, but still a fair reason for eviction, would include things like the property owner themselves is going to move into that property. We're seeing this a lot during COVID-19, especially from small landlords, people who maybe only own one property and now they decided they cannot keep up with owning more than one and they need to move into the one that they rent, right? It could also be that the owner is moving in a close family member, not necessarily just themselves. There are other no-fault reasons. Certain major renovations can qualify. Um, Sometimes an owner might be ordered to vacate a unit if it turns out it's not permitted, things like this. But in all those cases, if a landlord does evict a tenant for a reason that was not their fault, the landlord must give the tenant relocation assistance. So assistance equal to 1 month's rent. And we're going to get into rental debt in a moment, but if a landlord evicts a tenant for any of these reasons, not about paying rent, which we're going to look at separately, then the landlord won't be able to collect any rent that the tenant may have missed because of COVID-19. I'm going to explain all of that right now. And I should just say too that these protections have been extended through August 1st, 2021. After that, unless it's extended again, it will shrink back to only being subject to these certain properties here. All right, so now let's talk about evictions for not paying rent. So this is really important information for both landlords and tenants to understand. It is a little bit complicated, but I'm going to try to break it down in a helpful way. And this comes from the COVID-19 Tenant, Homeowner, and Small Landlord Relief and Stabilization Act. This is also called AB 3088. It was recently extended. That extension is called SB 91. It is all the same thing. And this is what it is. It says that a tenant has a defense against eviction if they cannot pay their rent due to COVID-19. The tenant will have to pay that rent. They will have to pay it back, but they cannot be evicted for it. And tenants have to take certain steps to be protected. It's not automatic. Those steps, we're going to go into them, but just as an overview, they involve a form called the Declaration of COVID-19 Related Financial Distress, and they involve paying a portion of the rent. So first of all, this protection is designed for people who can't pay their rent because of COVID. So the reason should be related. Some really common examples are that the person lost income because their workplace shut down, or people were fired or laid off, or furloughed. Childcare expenses because of COVID-19. The schools are also closed, and that means someone has to take care of the child, and that can be expensive. Medical expenses from COVID-19, absolutely, whether it is the tenant themselves or someone they're caring for who has COVID-19. But these are just examples. There are millions of ways that we're all being affected by this pandemic. And if you don't see your situation here, speaking at this moment to tenants, you could very well still be covered under other impacts. So just wanted to give examples, but this is a very expansive, very broad understanding. So this is the declaration of COVID-19 related financial distress. What I hope to show is that it's really not as complicated as it sounds. And I want to just go through what it looks like. It is a specific form that comes from the state, but the tenant pretty much just has to fill it out with their information. So it'll say, I'm going to paraphrase going through this. Dear landlord, this declaration letter is in regard to rent payment for the following months. And the tenant can write in the month, or if they're using one of these tools I'm about to go over, they can check off the month for every month that they need to defer the rent. It says, I am unable to pay my rent because, and then it just lists a bunch of those example reasons that we just talked about. Loss of income, increased expenses, childcare expenses, etc. Then it says, even if I have received public assistance, even if I have received disability or unemployment or paid leave from work, it is still not enough and I still can't pay my rent. I declare under penalty of perjury, right? I swear to the court that this is true. That's the whole form, signed tenant. So there's a couple of different places to get this form. First of all, the state itself, the state of California, has provided a website called Housing is Key, housingiskey.com. And it has all kinds of resources. It has legal guides, it has just a breakdown of the information, and it also has a blank copy of this form, as well as copies of forms and notices that landlords may need to use. And I will talk about that in a moment. But all of it, everything that you could need, is at housingiskey.com. For tenants, I also recommend going to norent.org. Norent.org is a partnership of some of our fellow nonprofits, and it's basically a tool to fill this form out online. And again, all you have to do is fill in the blanks and sign, and it will actually mail this declaration form to the landlord for you. So I think that is really, really helpful, and is a good way to easily just make sure that it is sent and received. It is free, is available in English and Spanish, is available for all of California, so I recommend it. But it's not required. You're welcome to get the form from Housing is Key or from us and fill it out on your own as well. So I mentioned briefly, this form should be turned in for every month that the tenant wants to delay or defer their rent, for every month that they need to miss the rent. For past months that you might want to cover if you have not already given this form, you can just do one form for anything in the past. But going forward, you do want to turn in a form every time. So every month, every separate time that you are not going to pay your rent, you want to make sure you're covered with this form. For tenants who earn less than $100,000 per year, no documentation is required. No documentation of the financial impact or your financial situation, just the form. For tenants who earn more than that, the landlord can request documentation, but there are still no requirements on what that documentation is. It's again very broad. Everybody is in a different situation. It would be too difficult to try to standardize this. So anything that the tenant can get their hands on that shows, that verifies somehow that they've been impacted financially by COVID-19. And when I say impacted, I stress that because this does not call for something like a bank statement, right? The question is not how much money is in your bank account. The question is, have you been impacted financially by COVID-19? So that could be a letter from the boss saying, we've cut your hours, or anything along those lines. It does not have to be a pay stub or a bank statement. There are some other protections involved in this as well, from SB 91, the extension, just about how to handle these payments that have been missed. So a tenant's current rental payment should not be applied backwards to debt that is owed, right? So if I'm trying to pay rent for February 2021, that money goes toward my February 2021 rent, not the rent that I missed in May 2020, right? And we do recommend for tenants that if you pay rent with a check or online, you write a little memo about the month that it's for. And similarly, if you're paying down your debt already, write a little memo that is for the debt. But this is important to know. Security deposits cannot be applied retroactively to the debt without the tenant's written permission for as long as the tenant lives there. If the tenant does move out, at that point the security deposit can be taken for the debt, excuse me. Also, there should be no late fees and no interest on the rent debt. And when I say rent debt, just to clarify, I'm referring to any debt that was any rent, excuse me, that was missed during COVID-19. So basically since last March, and that has been covered by the form, the declaration form. The law also says no new or increased fees on services. And this is basically just to make sure that there's no loophole in the no late fees requirement, that someone wouldn't simply try to impose a fee somewhere else. But on the flip side, during this public health emergency, landlords can reduce certain services. So for example, close the pool or close a small common facility where people would be really close to each other. If it is for public health, it is for COVID-19 safety, the landlord can reduce the service without then lowering the rent. Because normally with the reduction in services should come a reduction in rent. But right now, if it's for the sake of public health, the landlord does not have to reduce the rent. That's sort of the flip side of the no new or increased fees. All right, so how does this end? So it's been extended. We shall see once we get into the summer whether it will be extended again. We'll have, depends on the situation with COVID-19, quite frankly. But here is how the timeline is currently going to work. So by June 30th, tenants should pay a portion of the rent that has accrued since September 1st. And that portion is 25%. So starting September, the rent continues to add up, right, through June 30th. And by the end of that period, the tenant should pay a quarter of all the rent since that time. So it does not have to be paid monthly. The tenant can choose, if they wish, to pay it all June 29th. That may or may not be something that the tenant wants to do, because remember that this law creates a lot of debt. And as the tenant, you may not want to have that debt long term. So it's up to you to decide, but think about what you can afford now versus debt you might carry later and make that decision on your own. But again, just to reiterate that timeline, so any rent that was missed since March, from last March through August, did not require any partial payments, just the declaration form, no payments. Starting September, that's when the payments start to add up. So September, 25% of that rent, all the way through June 30th, right? That's the partial payment requirement. After that, that is the end of when rent can be deferred. So as of July 1st, there is no more declaration form. There is no more paying partial rent. There is just regular monthly payments. I'm so sorry, I randomly have a Burbank information in there. My apologies for that. I will take that out when I when I email you these slides. But the date for tenants to start paying back the debt, right? So we've gone to June 30th with partial payments. July 1st, tenants are paying normal rent. And as of August 1st, 2021, that is the absolute earliest that a tenant has to begin paying down their debt. So nobody has had to pay down debt until now. You can, if you have it, if you want to make a dent, but it is not required. And as of August 31st, 2022, that is the end date for rental repayment. Again, I apologize for this random Burbank. Ignore, that's a local variation, but it's going to be a year period for tenants to repay the debt that they owed. So again, that year is from August 1st, 2021 to August 31st, 2022. And it doesn't matter if it was 1 month that the tenant missed or if they have missed every single month since March. It is all subject to the same deadline. So remember that until this point, the steps that the tenants have been taking, the declaration form, the partial payment, all of that stuff, has been to protect the tenant from eviction over this rent. But they still have to pay it. And if they don't pay it, what the landlord can do instead of eviction is go to small claims court. This is new. We are all going to be seeing together how the courts handle these cases. We are going to provide all the information that we can, but it is just as new to the courts as it is to you or me because they don't usually handle these cases. But that is the process to recover this debt. So again, at no point can the tenant be evicted for this rent, this specific covered rent, until July 1st, right? Meaning the rent that has come due since March through July 1st, right? Instead, if the tenant does not pay back the rent, it's small claims court. And all the restrictions are waived. I don't know if people are familiar with small claims court, but there are typically restrictions on how much can be at stake, right? It's supposed to be for small claims, things like that. All those restrictions are waived. So no matter how much money it is, it's going to go to small claims court. Yes, this is what I should have showed you. August 1st to August 31st, 2022, right? So I did want to also just summarize where all of these things can be found. So that's the end of the sort of legal information on this topic. But I wanted to share where more information, all of the forms, the notices can be found. And so again, the website from the state of California is Housing is Key. It's going to redirect you to landlordtenant.dre.ca.gov, but Housing is Key is the sort of shortcut. And for landlords, you will want to visit that because they have all of the forms and notices that you may need. So if a tenant does not take these steps, they have not paid rent, but they have not taken the steps to protect themselves, the landlord can give them a 15-day notice, a notice to pay or quit. And that notice time has been extended to 15 days. It's usually less. But there's a specific notice for that, which can be gotten from the website. And the landlord should also attach a blank copy of that declaration form to basically say, a pay or quit notice basically says you haven't paid your rent, you have to pay your rent, or you have to leave. In this case, the pay or quit notice is saying, hey, you haven't paid your rent. You have to either pay your rent, let me know that you're protected for not paying your rent, or leave, right? There's also the form there if you do want to request documentation for a tenant who makes more than $100,000. You want to request documentation of their financial impact. And there is the form there if you eventually get to the stage of filing an eviction, an unlawful detainer. I also want to flag that because this extension of these protections is so new, it just happened in January, there is a requirement right now for landlords to notify tenants of these rights. So any tenant who is missing rent as of February should receive a notice from their landlord that says, this is SB 91, this is what you can do to avoid eviction for not paying your rent. And that has to be given by the end of this month. And it is, again, at housingiskey.com. Everything that you need is there. But I did want to flag this deadline for this notice. So, like I promised, a lot of information. The last thing that I want to share is just some resources. So maybe I will do that before returning to questions. It's just a couple of slides, if you'll bear with me. So some resources for homeowners. For federally backed mortgages, which is the majority of mortgages in this country. And so that would be Fannie Mae, Freddie Mac, FHA. They are not going to do any foreclosures or evictions from this housing until June 30th. This was just extended. You can also request a forbearance, a delay on payments, and you can make that request by June 30th as well. The first forbearance that you can request is 6 months, and then you can request further extensions 6 months at a time. For homeowners, again, with federally backed mortgages, there's no documentation required to prove that your finances have been impacted. There's going to be no additional fees or penalties. They're not going to raise the interest rates. All of this is happening now for federally backed mortgages. And I have here some links. First of all, a summary on the program. You can either use this link at the bottom or just click. You should be able to click through when you get this on this square. And then also, I included some information here on how to tell if you have a federally backed mortgage. If you don't know who owns your mortgage, very common, this is a guide to figure that out. And basically, I can give you the short answer. If you have the document, there's going to be a box that says it. And if you don't, you can call your servicer. That's the short answer, but there's more instructions here. If you don't have a federally backed mortgage, you're with a private bank. The state of California has also partnered with a lot of banks to provide various forms of relief. So this one might differ according to your bank, but they're generally along the lines of grace periods for payments, no late fees, not initiating any new foreclosures. And important to know that if you use any of this relief, it's not going to impact your payment score. Your credit score. And if you make a late payment, it's also not going to impact your credit score. So there is a link here at the bottom of the page that shows all of the different banks participating in this. Like I mentioned, there's a lot, and some of the bigger ones I have listed on here: Citigroup, Chase, Wells Fargo, US Bank, but there are many more. So please do check. And when in doubt, if you're not sure if you qualify for any of these things, I would call your servicer because they probably do have options, or call your bank. If you do request a mortgage forbearance, and for some reason it is denied. Again, this is if it's related to COVID-19, if it's denied. The state of California has said that the lender must provide a detailed explanation of why they are denying your request. So this is to sort of make it a little bit harder to deny the request. And they must give you 21 days to make any corrections that you might have to make in your application. So if the reason that they denied you was because you gave the wrong information about something, or you didn't understand their question that they asked, or you didn't include something, you have time after it's rejected to correct that and resubmit. And these protections are going to be in place through September 1st. So this was also a recent extension. For tenants, I want to share legal aid resources. This is very important. Tenants, I strongly urge you, if you receive a notice from a landlord, certainly if you receive something from the court, don't try to go it alone. Please get free or low cost legal aid from someone who deals with these forms every single day, because the bureaucracy around it is kind of strict. There's strict timelines, there's paperwork, you have to get it right, it's very technical. So please, please, please come and see an attorney who can make sure that you at least get a chance to raise your defense in court. All right. And I will send this out. I know this is like a lot of different names on one slide, but these are all the legal aid resources in the Ventura area that I'm aware of. And now I am happy to take some questions. I know we are just at 5, so I apologize for going a little bit over, but I personally am happy to hang out and answer more questions. I think everyone else should feel free to leave when you have to, but I'm happy to stay.
Wonderful. Thank you so much. This information has been really helpful. I know that I've learned a lot, and if you are able to provide me with copies of these slides, I will email them out to everybody who registered for today's program. That way you guys can take your time and go through them and find those important resources. And we have also been recording this, and we will post it on the Senior Concerns website. So if you go to seniorconcerns.org, under events, there is a seminars tab, and you can view all of our past recorded seminars as well as sign up for future seminars. So I know that we do have some questions. So for those of you who got your questions answered, we thank you so much for joining us. And for those of you that are waiting, we'll stay on, no problem. I'm happy that you're willing to do that and answer your questions today. So thank you.
Yeah, no problem. All right, so let me work through some of these questions. I do want to say that some questions, if they are very specific or very personal, I would actually recommend contacting us and speaking to one of our counselors because it's confidential. It's private. And also, we can just take a little more time to sit with you, look at any documents you might have. So if I see some very personal questions here, I may try to answer them in a general way or refer you to our counselors, because we are in sort of a public forum. I don't want to jeopardize anyone's details, but let me see. Okay, here's a question about fair housing. How does a tenant prove that a pet is medically required for emotional support? Yeah, that's a good question. So for support animals, there are actually different levels of like designations. So a service animal or a service dog is like the most um, sort of restrictive license or the highest threshold. So there's a specific license for that. They have to be trained a certain way, but there are also emotional support animals, as this person asked about, and the standards for that are much lower. And a good way to provide verification for this is a letter from a therapist or a letter from someone who is familiar with the situation and can sort of verify or vouch that this is necessary. It does not have to be a doctor. In general, for disability documentation, it does not have to be a doctor. And especially right now, because our medical system is slightly overburdened and people might want to avoid going to the doctor right now. But even if that weren't the case, anyone who is an independent third party who can verify this need, that is absolutely sufficient. I'm not sure if that answered the question, but I hope so. Okay, so someone asked, oh, there are so many questions from people who are going through something right now, which I'm sorry to hear, but I'm glad that we're in touch. So someone asks about renting a room downstairs. So I believe, and correct me if I'm wrong, but I believe this person is the homeowner. And the homeowner is renting out a room in the home. This person is having hip pain that makes it difficult to go upstairs to access the bathroom and the bedroom. Oh, and their own bedroom. Can I have this person move so I can move my bedroom downstairs? Yes. um, if you are the homeowner, you could do that anyway. You're typically not required to rent out any particular room. Just be aware of the current protections for eviction. I guess, let's see, if I were talking to you more privately, more personally, I would probably ask something like, have you talked to the tenant about this yet? You know, it's always best if you can to resolve just by talking to the other party, but sometimes you cannot. What is this person's contract like? You know, is there a specific anything specific that would make this more difficult to do? But in general, if it's a room in your own house, yeah, you can rent out a different room in your house instead. Mm, yeah. A lot of things, I'm sorry to say, a lot of things in housing really depend on the specifics of a situation. So I encourage this person to reach out to us anyway, just so we can learn a little bit more. But in general, I wouldn't foresee that being a problem. Okay, so this person is asking about accommodations as well. If a tenant had in their previous contract with previous owners that the rent would be due on the 5th of the month rather than the 1st due to when their monthly wages are paid, can that be an accommodation? So an accommodation has to be related to a disability under the law. In my opinion, this request that you have is not unreasonable, but legally speaking, the accommodation comes in when it is tied to a disability. A new owner may be able to change the terms of a lease. Since this is about monthly wages and not something that is tied to a disability, they may be able to do that. It is, you know, there are some other contingencies that could come into play. What kind of property is this? If you're in Ventura, then I suppose that you don't have rent control. But in some cases, a new owner might have to honor certain portions of an old lease. So it sort of depends if you have your lease and you're able to see whether it says anything like that. But basically, you know, the short answer is that this is not something that you could make what's called a reasonable accommodation request for, because it is not tied to a disability. So yeah, so there are a lot of gaps and things that can still sort of go wrong, I'm afraid. I am seeing a number of questions about buildings that were sold. Um, and they do vary, but I did want to say one general thing about buildings being sold, which is that a building being sold is not a just cause for eviction. So, again, through August 1st, everybody in California must have a fair reason to be evicted. And the building being sold is not a fair reason. So nobody should be receiving an eviction notice simply because the ownership of the building is changing hands. It could be that the new owner might do something that would then create an opportunity for eviction. Like maybe the new owner is going to move into the unit, maybe the new owner is going to demolish the unit, something like this. But simply the sale itself is not a valid reason for eviction. Okay, I see a question about how landlords can pay their mortgage and property taxes, and I hope that I somewhat answered that with the resources. This also reminds me to speak just a little bit about the rental assistance program that the state of California is going to launch soon. I didn't cover it in the presentation because it's not launched yet, but we do know a little bit about it. I think a lot of people think of rental assistance as a tenant relief source, but actually, that money is going straight to the landlord. So it is actually landlord relief as well. And I think landlords would really benefit from taking advantage of it. And what the California program is going to do when it launches, it's going to basically provide the option for landlords who agree to participate. The state will pay 80% of what the tenant owes or has missed if the landlord agrees to forgive the remaining 20%. Now, in a lot of cases, that's frankly going to be a good deal because a tenant who is not able to pay their rent right now may very well still not be able to pay it come August. So in many cases, that's going to be the wiser option financially. Of course, I can't make that decision for you, but that's my perspective. It's a guarantee that you're getting 80% of the rent back now, right? If a landlord refuses to participate in the rental assistance program, then the tenant can still apply for relief directly, but it will only be 25%. So basically, to fulfill the requirement to pay partial rent by June, it will be enough for that, but not for the rest of the rent that might be owed later. And I will also say there are some incentives for the landlords to accept this rental assistance. If the landlord does not accept it and does not, attempt to participate in a rental assistance program, any rental assistance program that the tenant has brought, or even seek out rental assistance, then the judge in small claims court, which is where you'll end up if the tenant doesn't pay their debt back, the judge will be able to lessen the amount that the tenant owes if the landlord, again, has refused to accept rental assistance. In other words, they're saying, you had the option to get this money. Why didn't you take it? And again, the judge may not decide to do this, but they can. So again, just to state, the rental assistance program from the state is not out yet, but that's what we know about it. It will be coming through the cities and the counties. They're going to be the ones administering it. As soon as we know more about that, we will be publicizing those application systems widely, but they don't exist yet. Okay, yeah, I see a question about people entering the unit, landlords and people representing the landlord trying to come in to the tenant's home. So this person says they've had multiple walkthroughs last year, pre-pandemic, and an appraisal walkthrough a couple weeks ago. Oh, I see. Um, so there's some details here, but basically the question is asking, is it reasonable to ask if the owner or others will need access to the apartment in the near future? Yes, absolutely, it's reasonable. And this is reasonable in both senses of the word, both just from like a common sense perspective and also legally speaking. If your household, someone in it, is vulnerable to COVID-19, you're in a high risk category, whether that's because of age, underlying condition, possibly also because of exposure. If you're, for instance, a healthcare worker, that is considered to be disability related because, again, COVID-19 is covered by the disability protections, and that includes association. Remember, early on, we talked about protections against discrimination by association, which would mean, in this case, that could translate to being exposed to someone or associated with someone who has COVID-19. So anyway, so in all of these cases, this is about the potential of disability, and therefore, it is a reasonable accommodation request to ask that the landlord, I mean, this person only asked about if they could let you know, which they absolutely have to, regardless. But it's reasonable to request that they just don't come in for now until you're no longer vulnerable. And when that is, we don't necessarily know. It might be when you get the vaccine. It might be when 51% of the population has gotten the vaccine. It's not entirely clear, but you can certainly make that case. And if you need help making that request, again, HRC does help with this kind of request. The other element of this question was about difficulty receiving notice because of mail issues and power issues. If you've informed the landlord of these issues, they should give you notice in a way that they know that you can reach it. So whether that is putting it on your door or sending you, I don't know, an email or a text or whatever. I mean, really, there is a written notice form. And they should be giving you around, let's say, 24 hours. It's not typically defined, it's not technically defined, but a reasonable amount of notice. So that is regardless of the disability issue. That should just be happening, that you get notice. But again, just to recap, you can absolutely request on the basis of disability that they just don't come in for now. Okay, so here's a question about, I think, yeah, okay, so here's a question about perhaps there's a new contract coming around, your contract is going to be up, it's time to renew, or perhaps there's a rent increase that is scheduled or going to occur. And this person says, someone in the household is not working, so perhaps their income threshold, their income would not meet the threshold that is required if they were applying new, right? So let's say an application says you must make 2 times the rent, and this person already lives there, so they've already gotten past that stage, but now they have perhaps lost work, and if they had to apply again, maybe they wouldn't meet that requirement. But rent is still being paid on time by others in the household. So this should not be a problem because really what the landlord needs to know is about household income. Not every single person on the lease has to be paying equally, that's not really the landlord's problem, right? I mean, if there were children in the home, they wouldn't be contributing, right? There's lots of different reasons why someone in the household wouldn't be bringing in income, lots and lots of different reasons. And that's not required. It's not required that every single person meet a specific income requirement or contribute in a certain way. It's just required that the household be able to pay the rent or whatever income threshold they have set to indicate that twice the rent, three times the rent, etc. But it's not down to the individual person. Does that answer your question, anonymous person?
And I do apologize, but we will have to wrap up.
Yeah,
I have so
I see that now.
anything extra. Um, but I think you've answered most of them. There is a request for your contact information again,
Yeah,
but we
absolutely.
will also make sure to email that out to everybody as well. I don't know if
Yeah.
there's any last comments that you wanted to make based on those. And then if people have more specific questions that didn't get answered, reaching out directly will be best because like she said, it's hard without knowing all of the details because the situations can be so different,
Yeah.
so specific.
Yeah. Yeah, I would just say please don't hesitate to contact us. That's literally what we're here for. So happy to answer your questions. And whether it is through the hotline or an appointment or another workshop, or if you want to message us on Facebook, it does not matter. We will find and answer your questions. So please feel free.
That's wonderful. I didn't know that you could schedule an appointment.
Yes,
I think
yeah.
that's a great option because I know the hotline, oftentimes you'll leave a message and then you have to hope that you're available when they call back. So I like that. Makes it a lot more convenient for
Yes,
people.
good. I'm glad.
So I thank you so much for taking the time to speak with us today.
Of
This is
course.
such valuable information. And again, it will be posted on seniorconcerns.org, hopefully sometime tomorrow. So thank you to Elana Eden and the Housing Rights Center, and I hope you all have a wonderful evening.
Yes. Thanks to everyone. Have a great night. Stay safe.
Thank you. Good night.